It's Mark Gracie here from Flavify Digital. I'm going to be running the webinar today. Thank you very much for joining this General Data Protection Basics webinar. I'm recording the session, so I'll send out a link to the recording at some point after the webinar's ended. And just to let you know, if you've got any questions, I plan on talking for probably around 30-40 minutes. So there should be plenty of time for questions at the end. If you've got any questions, there's a questions section in your control panel, which you can use to type a question. Feel free to do that as we go, or we can pick those up. But what we'll do is we'll pick those up at the end, and hopefully plenty of time to answer all your questions. So just very quickly, as I said, my name is Mark Gracie. I run a consultancy called Flavify Digital and an online resource called Digital Compliance Hub. My business is all about helping businesses with GDPR at the moment, but I also work with privacy controls and marketing compliance, as well as web and data security. My background, I became a data protection manager in 1998 when the Data Protection Act became law in the UK, and helped, I was working in the internet industry at the time, helped an internet service provider become compliant, which was no mean feat given the amount of data that that the organisation had and the size of the business, and bringing everybody in line with understanding as employees their roles and responsibilities, and that led to a 15-16 year career in a regulatory role, mainly focused around internet and telecoms regulation, but data protection and data compliance and data retention as well. So the purpose for today's webinar is to do a very basic introduction to GDPR and what that means. So by the end, hopefully, you'll have a good understanding of what GDPR is all about. Hopefully then be able to work out whether that's something you need to worry about, which if you're processing personal data, which I'm guessing you probably are, otherwise you wouldn't be on the call, then you will need to worry about it. And some pointers as to the kind of things that you might want to think about in terms of what compliance might look like. I'm going to start with an intro to data protection, because the GDPR is an improvement to existing data protection rules, so it's important for us to understand the basics of data protection. I'll then talk about the General Data Protection Regulation and some of the changes that are coming in with that. And as I say, if you've got any questions, feel free to type them as we go, or pick them up at the end using the question panel in your GoToWebinar control panel. So let's make a start, and let's talk about data protection. So there's lots of definitions. I think the GDPR's got over 40 of them, and there's quite a lot. There's quite a lot that are missing, to be honest, but probably the 5 key ones are those 5 that are showing on the screen right now. So data protection is all about personal data, and that's any data that helps you identify a living individual. Now that will mean obviously your clients and your employees, but it also means any business contacts you have as well. So it's not just about individuals, it's also about any individual in a business that you can identify from the data, because if you can identify them, then that's personal data. So it's not just about your customers and your employees, or just about consumers. In the B2B environment, it's also any businesses that you're doing business with, or your suppliers or your contractors, and so on. So if you can identify a living individual, then it's personal data, and therefore data protection applies. And it applies both whether that data is directly referencing some personal information, or if you've got some other data which, with that other personal data, you can identify the individual from, then that other non-personal data is also considered personal data. So if you've got a data set that doesn't have any personal data in it, but you can use that with another set of data to identify an individual, then both sets are considered personal data. Now, the actual use of that data is referred to as processing, and it's important to appreciate that actually processing has a very wide definition. It's not just about the use for which you collected the data in the first place. It covers the storing, the editing, the deleting, the sharing, the manipulating, the analysis, the use of the data for which you collected it, and so on. So pretty much anything that you might be doing with the data is considered processing, and therefore data protection applies. Now, the three key players when it comes to data protection are the data subject, the data controller, and the data processor. The data subject is the individual whose data it is that you're processing. The data controller is the organization that's collected the data from the data subject and is determining how it's going to be processed. And a data processor is a third party that the data controller might have asked to do some processing for them. So in a very simplistic email marketing scenario, the email addresses that are collected for email marketing belong to the data subjects. The company who's collected those email addresses from the data subjects would be the data controller. But if they then pass their email list to a third-party marketing company for the purposes of doing their email marketing, then the email marketing company is the data processor. If you're doing all the processing, then you're the controller and you carry out the role of a processor. It's only when you're using a third-party processor that you need to consider the ramifications of what that might mean. And that's quite important for one of the changes that's coming with the GDPR, as is the wider definition of processing and what that might mean to your organization. So those are the key definitions. Now, in terms of the rules about what you can and can't do with data, they're referred to as principles. The Data Protection Act had 8 of those, but only 6 of them were carried forward as principles in the GDPR. The other 2, which are individuals' rights and international transfers, still exist in law and they're still in the GDPR. They're just not referred to as principles. And the GDPR introduces a 7th, which we'll talk about when we start talking about GDPR. So basically, if you're processing data, you must do so lawfully, fairly, and transparently. The lawfulness of processing, we'll talk about in a second. The fairness and transparency is about being open and clear as to what it is that you're processing data for, so that the individual understands how you're going to be using their data. You must only process the data for the specific purpose that you collected the data for in the first place. So you have to have a lawful reason for processing. If you're collecting it for a specific purpose, that's the only reason you can use that data, or the only lawful reason you can use that data, unless another lawful basis for processing applies. The data you collect has to be relevant, so you must only collect data that you need. If you don't need date of birth or postal address, then you shouldn't be asking for it. You must keep your data up to date and accurate. So if a data subject tells you that their address has changed, or another aspect of the data that they've supplied you has changed, then you've got a duty to make sure that you've updated your records. But also, if you've shared that data with a third party for some processing or for whatever reason, they need to make sure that they update their records as well. You must only keep the data for as long as it's lawful for you to do so. So if there is no lawful reason for you to continue storing the data, even though you could just keep storing it for forever, you mustn't. You must delete data that you no longer need. And if there's data that you don't need in a personal point of view, so you don't need the personal data of it, but you want to keep the data for, say, statistical analysis, then you should do that, but you should anonymize the data and remove the personal data, and you can keep that data for as long as you like, because it's not identifying individuals. But if it's personal data, only keep it for as long as you have a business reason to do so, or it's lawful for you to continue to store it. And then the thing that most people think about when they talk about data protection is the security. All processing, bearing in mind that wider definition of processing, must be done securely. So whether you're sharing data, whether you're processing it for the purpose you collected it, whether you're storing it, and so on, all that has to be done in a secure way. Now, individuals' rights and international transfers, as I said, those are key rules, and it's important to understand those. And we'll be talking about some of the changes that are coming with individuals' rights in GDPR. There's 3 new ones and a change, but they're basically the rights that a data subject has about their expectations about the processing of their data, but also what they can expect to get from the data controller in terms of how their data is being used. And probably the most well-known individual right is the subject access request. So the request from the data subject to have a copy of their data, be told what they're using it for, and so on. And then international transfer, this is a rule that basically says you must only process data within the EU. If you process it outside the EU, then you must ensure that the country in which you're processing it has adequate data protection. Now, the problem is there aren't many countries outside the EU that have adequate, as in comparable with EU standards of data protection. So there is a very small list, probably a handful of countries that are available. If you look at the Information Commissioner's website about international transfer, or you look on the EU Council website, you'll see there's a list, and there's a small selection of countries who have adequate data protection. There's things like Israel and New Zealand on there, and a few others. Now, if the country doesn't have adequate data protection, then you need to look at what other options are available. So if you consider the two sort of obvious countries to think about, India, because lots of businesses outsource their call center management and customer services to Indian call centers, for example, or the US, where the data may be processed in the US, you've then got to look at, well, what's the adequate what's put in place to demonstrate the adequacy of the data protection. So there's a number of ways. So if the country has put in place an agreement with the EU, which like the US has a privacy shield, which is a EU-US agreement that any companies signed up to the US privacy shield will abide by European standards of data protection. If there are very few countries that have that kind of thing, and probably the US one is probably the most well known. But countries like India don't have adequate data protection laws in place. They don't have an agreement with the EU like the US do. So then it's a case of looking at contractual obligations, and there are standardized contractual terms that have to be used, and they're defined by the EU and published by the regulators. So the Information Commissioner can provide guidance on what these standard contractual clauses need to be. But those are the ones that you force in contractual law against the other company in terms of the processing of the data. Now, you may all be UK based and wondering why I'm labouring the point, but it will actually become a bit more apparent when I talk about controller and processor relationships a bit later on when we talk about GDPR. And as I say, there's an accountability principle, which is the 7th data protection principle according to GDPR, and I'll talk about that when we start talking about GDPR. Now, the rules and what make it lawful for processing, are the lawful basis for processing, of which there's a number of them, and the screen there shows the list of the 6. The one that everybody automatically assumes applies is that the subject has given you consent. So if the data subject has said, yes, here's my data, you may use it for the purposes for which you're saying you're going to use it, then you have consent, and that would be lawful for you to be processing the data under that basis. However, you shouldn't by default always assume you need consent, because there may be other reasons why it's lawful for you to process the data. And so you shouldn't always default to consent. So if you don't need to ask for consent, then you shouldn't be asking for consent. So therefore, it's important to understand the other lawful basis for processing as well. And you need to make sure that you choose the right one that applies to your circumstances. So the next one, required for performance of a contract. What that basically means is that if you need data for the purposes of delivering a service, so somebody's entered into a contract with you for the provision of a service or a product, it is lawful for you to process the data that's necessary to actually facilitate that service or contract. So, for example, if you're an e-commerce site and you're selling products and you need to be able to dispatch those products to a postal address, it would be lawful for you to process that postal address for the purposes of dispatching the products. You wouldn't need to ask consent for the use of sticking it on an envelope or on a parcel, or for using it with a courier for the purposes of delivering your product. The lawful basis for processing is that you need that address for the purposes of actually delivering the product that somebody's ordered through your service. You may be legally obliged to process data. So that means that there may be law or there may be regulation that says you need to process or keep data for a certain period of time. The obvious examples are the taxman says in the UK that you must have 7 years worth of records. So if they come and audit you, if there's personal data in those records, then it would be lawful for you to keep that data for 7 years for the purposes of satisfying a tax audit, even if you don't need the data for any other reason. So if there were no other reasons why you were processing the data other than tax law, then that's you would claim that the lawful basis for processing is you have a legal obligation. The other common one to think about is in HR law, or employment law. It would be lawful for you to keep data of an ex-employee for up to 6 years, because that's the period by which that they could take you to tribunal if they wanted to, and so you need to be able to defend yourself. So therefore, that would be your lawful reason for continuing to process, even if it's just storing in a filing cabinet or in a database, ex-employees' details for up to 6 years. And then there's lots of other regulations. There's, in the care sector, there's regulations around safeguarding and data and how long you keep data and so on. Depending on what you're doing, you may be able to claim that it's in the vital interests of the data subject that you process their data. And the kind of example would be sort of a life and death scenario where, say, a doctor is talking to a patient who's showing signs that they might harm themselves, and it would therefore be lawful for the doctor to share the patient's data with the emergency services or a counsellor or a consultant for the purposes of protecting the data subject. So if you're in an industry where there's, I guess, care and potential life death scenarios with your data subjects, then that may be something that you might need to rely on in terms of lawfulness of processing. The green one there in the public interest, if you're a public body, then you could claim that it's in the public interest for you to process data. So you need to be clear on the circumstances by when that might occur. But if it is lawful for public bodies to process data, if it is in the public interest, the circumstances for that will vary depending on the situation. But you would need to look and see whether, that doesn't necessarily mean that you claim that everything is in the public interest, but if there's a need to process personal data for security or some other general public interest, then that might be the lawfulness for processing. And then finally, a grey area, or a tricky one at least, called legitimate interest. So it is possible to say that you have a legitimate interest in your organisation for the processing of the data, but you have a number of hoops you've got to jump through to actually prove that there were no the legitimate interest is in fact the lawful basis for processing. So this makes this one quite tricky, because you've got to be sure that there were no other lawful reasons, lawful basis for processing. So if you could have got consent, then you need to get consent. You can't claim legitimate interest in not asking for consent. Equally, if you need the data for the processing of a contract, you wouldn't have a legitimate interest in processing for the purpose of that contract, because the lawful basis would be because it's required for the performance of a contract. So you've got to be sure that there's no other lawful basis for processing. You've got to be sure you can demonstrate that the processing is absolutely necessary, that you need to process it and you've got no choice. And you've got to be able to demonstrate also that there's no harm to the rights and freedoms or privacy of the data subjects. So there's three hoops that you've got to jump through there. Now, there is a paper by the Data Protection Network, which has been kind of signed off by the Information Commissioner's Office in the UK, that talks about legitimate interest and also gives a legitimate interest assessment. And so you might find that if that's something that you're having to think about, then that you might find reading that paper is quite helpful. Now, one of the ironies of data protection, which I like, is that it is lawful for you to maintain a list of people who have unsubscribed from your mailing list for the purposes of knowing that they've unsubscribed, so that you don't accidentally add them again. And you would say that that is a legitimate interest for the purposes of direct marketing. So it's those kind of things that you've got to think about. So there's clearly no harm. You wouldn't be asking somebody for consent because it wouldn't be relevant to do so. You don't need the data for any other purpose other than to make sure that you maintain your mailing lists and you don't accidentally email somebody or do some marketing to somebody who has opted out. So that would be a legitimate interest by way of example. So that was a very brief introduction to data protection. I'm going to move on now to talking about the General Data Protection Regulation and what that actually means. And so there's a fan diagram there that represents the 10 key things that are coming with GDPR. Now, from a scope point of view, the important thing to realise is that this is a regulation, so it's a European regulation. In European law, you either have regulations or you have directives. So our existing UK Data Protection Act is based on a 1995 directive. And the thing with directives is it's left to member states to determine how they implement that in local member state law. The problem with that is different member states interpret the rules or implement things in a completely different way. So what happens is you end up with a guy in Germany who has very strict data protection rights and expectations, but he doesn't know that his data is going to be processed in a different way in the UK or the France or Spain, for example. So also in European law, you can have a regulation, of which the General Data Protection Regulation is a regulation, and that applies across all of the member states, replacing all member states' equivalent laws. And the benefit of doing that is the guy in Germany will now know that his data will be treated with the same controls in Germany as it is in France and Spain and England and anywhere else in the EU. So it's quite important to realise this will be replacing our Data Protection Act 1998. However, there is a data protection bill being debated at the moment, which will lead to a Data Protection Act 2018, probably in the next couple of months, which essentially says the GDPR is UK law. The UK government tend to like to do these kind of things, but they don't actually need to do them. However, because of Brexit, it's quite important that they're doing it because they want to be able to demonstrate that GDPR is UK law after we've exited Europe. So GDPR applies across all member states and replaces all member states' equivalent laws, including the UK's Data Protection Act 1998. It also impacts on businesses outside the EU who are selling services or goods aimed at EU citizens, and there's a few checks and balances that would be in place to determine whether that's happening. But what it means is if you're targeting European citizens outside of Europe, GDPR still applies to your processing of their data for that purpose. And one of the checks is that is proving that you're actually targeting them. And so if you're a US company and you produce an Italian worded website, it would be difficult for you to demonstrate you weren't targeting Italians in Italy, which is part of Europe, and therefore GDPR would apply. It's those kind of checks and balances that are in place. And in some circumstances, those organizations outside Europe will need to have a representative within Europe acting on their behalf when it comes to data protection. And there's a slight definitional change, not that I think they really needed it because I think it's pretty obvious, but online identifiers are specifically mentioned as personal data. So if you've got website logs showing IP addresses and you can use that data to identify an individual, then those IP addresses will be personal data, as would be any other online identifier like social media handles, like your Twitter handle or your Facebook identity and so on. So online identifiers, without any doubt, are considered personal data. Now, I mentioned this accountability principle being a new principle of the GDPR data protection. It basically is saying it is up to the controller and the processor to demonstrate that they are GDPR compliant and that they have everything in place to ensure that compliance. So what that actually means is that you need to be able to demonstrate all of your compliance. So when I was talking about legitimate interest, I was saying, you need to be sure that there were no other lawful basis for processing, that there was no harm to the subjects, that you really needed to process the data in that way. That's all part of what accountability is all about, is you demonstrating that you are compliant. Now, there are some rules that say that if you're processing and you're of a particular size of organization or doing a particular kind of processing, then you are also obliged by law under GDPR to actually record your processing activities and be able to provide that documentation to the Information Commissioner if and when asked. But as a general approach, if you're demonstrating your accountability and you're demonstrating that you're actually compliant, it's probably best practice to have documented as much as you possibly can, because that's the bit that will, you can say, well, actually, we thought this through and this is what we concluded, and therefore, this is our approach, this is our policy, this is what the board decided, and so on. So I think whether you fall under the requirements of the regulation, which is to say, for example, you've got more than 250 employees, you will need to therefore record your processing activities. I think it's best practice for pretty much any organization to record its approach to data protection purely to be able to demonstrate that compliance. And you'll see accountability cropping up throughout as we work our way through GDPR changes. Now, if there's anybody offering online services aimed at children, so the GDPR talks about information society services, which is European law speak for online, and you require consent from the child for the processing of their data, then you not only have to provide child-friendly messaging, but you will also need to get consent from a guardian of the child as well as the child's consent. And depending on the kind of service you're running, that might mean you need to consider age verification software or practices or processes to ensure that you're able to determine whether the person is a child, and if they are, that you need guardian consent and mechanisms in place to obviously record that consent at multiple levels as well. Now, the regulation talks about, so the GDPR talks about a child being defined as under 16, but allows member states to determine their own local laws if they want. And the UK are currently talking about it being a child as defined as under 13. So if you're in the UK and you're offering a service aimed at children online, or is likely to be used by children online, then you'll need to consider these consent-specific rules around the consent from a child and also their guardian, and whether they are or not under 13. Now, in terms of consent, that leads us on quite nicely to one of the key changes that lots of people are getting quite excited, maybe depressed about, is that the consent rules are changing. So this is where the lawful basis for processing is consent. So you need consent from the data subject to continue to process the data. If you do need consent, then the messaging has to be clear. So the data subject has to understand what it is that you're asking consent for and what you're going to be doing with their data once they've given you that consent. But very importantly, that consent has to be given as a positive affirmative action. So that's the data subject saying, yes, I do understand why you're asking for this data and why you need me to consent to that. And here is my confirmation that I give you that consent. So what that means in reality is that you can't use pre-tick boxes anymore. So the pre-tick box, untick this box if you don't want to be marketed to kind of scenario, you can't do anymore. And you can't use any woolly or confusing wording that isn't clear to the subject as to whether they do or don't tick a box, whether they do or don't press a button or whatever. And you can't use phrases like, we'll assume that you're happy to give us consent unless you tell us otherwise, because that isn't a positive affirmative action by the data subject. So it has to be clear messaging and a very positive opt-in. And also, and this is accountability, you need to be able to record that you've got that consent. So you need to be able to demonstrate that somebody did understand why they were giving you consent, that they opted in, and the sort of date and time that occurred. And finally, you need to be able to provide the facility for somebody to withdraw their consent. And this is a problem with consent, is everybody has an absolute right to withdraw that consent at any time and by any means. So you'll need to have a process in place to effectively manage withdrawal of consent by the data subjects. Now, in a simplistic marketing model where you're collecting email addresses and you're using MailChimp for that, perhaps, and other email marketing solutions are available that have very similar functionality. Now, MailChimp has, for Europeans, by default, it's worth checking that it's turned on for your account, as a thing called double opt-in. So double opt-in isn't the law, but what double opt-in does is that, as well as somebody supplying you with an email address, they then get an email saying, are you sure you want to subscribe? If you are, then click here. You'll then add it to the mailing list. Well, that double sort of two-factor consent gathering is rubber stamping that consent, because MailChimp not only is asking somebody to really confirm that they're giving you consent, which is therefore the very positive way of doing that, but also MailChimp will record when you got added to the list. So you've got the accountability bit covered as well. So if there is double opt-in available, that's probably a good way of looking at how to deal with consent and meeting these requirements. But of course, you've still got to worry about the messaging, and you'll still need to be able to say, well, actually, this person joined this mailing list at this particular time because they will have read this text and they would have clicked on this, and then this process would have happened. So it's certainly worth looking at double opt-in if it's available as a way of verifying the consent and meeting the consent principles. But in practice, and the question I often get asked is, can you get verbal consent? Well, yes, you can get verbal consent, but because the accountability principle is up to you to be able to demonstrate that you got a process in place that meant the verbal consent was given and that you were absolutely sure that they were giving it and they understood what they were verbally consenting to and how you record that and so on. So the law doesn't say how you get consent, it just tells you you've got to make sure you've got it and it's a positive opt-in, and the means by which that consent has been given. So that's consent, quite a significant change that will probably impact most businesses in one way or another. Individuals' rights, I talked about those as part of when we were talking about data protection, as these are the rights that data subjects have. And there's 3 new ones and one that's changing. So the 3 new ones are the right to be informed, the right to erasure, and the right to data portability. The right to be informed, Articles 13 and 14 of the regulations set out the conditions by which you must tell somebody about the fact you have their data and how you're going to use it. And these are the kind of things that you would expect to see in your privacy policy or your terms of service and so on when somebody becomes a customer or you begin to process their data. The right to erasure or the right to be forgotten. This isn't absolute right, but it's the right the data subject has to ask you to delete their data so that you don't have any information around them. If there is another lawful reason for you to be processing the data, then that doesn't mean you have to delete the data. So the right to erasure isn't an excuse for somebody to say, delete all my data so that you can't bill me, or delete all my data so that you can't defend me when I take you to a tribunal. You will, if there are other lawful reasons for you to be continuing to process the data, then the right to erasure doesn't apply. The right to data portability is a right that allows a data subject to request a machine-readable export of their data from your system so they can import it into another. So in some ways, it's to enable the facilitation of switching services. So, you know, in a mobile telecoms world, you should be able to log on to Vodafone's portal, customer portal, say you're switching to EE, and it will not only facilitate that transfer, or you can export the data and import it into EE. And there's specific rules around what kind of data needs to be provided as part of that portability. But it's a machine readable export of the data that you might hold on them that they've supplied to you generally, plus some observational data as well. And then finally, subject access requests. This is the subject has the right to say, what data do you have on me? How are you using it? And can you provide a copy? You used to be able to charge under Data Protection Act £10 plus VAT for doing those, and you had 40 days to deal with them. Under GDPR, you can't charge £10 plus VAT. You've got to do it for free, and you've got a month, so you've got essentially 10 days less in which to deal with the request. So if you are in an organisation that has to deal with lots of subject access requests, expect them to go up because the freeness will probably encourage more people to do it, and some research recently suggested that that's probably going to be the case. But also, if you did have lots and you use the £10 plus VAT as an effective barrier to cut down on the numbers, that barrier has been removed, and that's essentially the issue that I think the GDPR is trying to address, is that people should have the absolute right to get to know what data is being processed about them, but they shouldn't have to be charged for the privilege of doing that. So 4 key things that are changing in terms of the subject rights of, the individual's rights of the data subjects, and 4 things that you'll need to think about how they are impacted in your organization. Another key change is the rules around the controller processor. So this will depend on whether you're a data controller or a data processor, and it's important for you to understand which you are, and you may even be a bit of both depending on what you're doing with data. But the GDPR basically says a data controller shouldn't use a processor unless the data processor is able to demonstrate that they are GDPR compliant, because if they're not GDPR compliant, then you'll not be able to demonstrate that you are. This is all covered in Article 28, and Article 28.3 actually lists a list of contractual terms that have to be put in place between the controller and the processor, and they range from very obvious things like not processing the data unless instructed to do so, right down to allowing the controller to come and audit the processor to ensure they are GDPR compliant, and there's quite a few in between that. So if you're a data controller and you're using a third-party data processor, you'll need to carry out due diligence on that third party, and you'll need to work out how you're going to get these contractual terms in place, which might be an addendum to the contract that you have with them, or an update to their terms of service perhaps, but you'll need to look at those. But what you need to do is you need to bear in mind that wider definition of processing. So when we think about storage and what that actually means, well, if you're using a CRM like Salesforce or HubSpot or Zoho, if you're storing your data in Excel spreadsheets on Dropbox or OneDrive or BoxNet, then they are all processing your data, because storage is included in the definition of processing, and therefore you'll need to carry out due diligence, or at least ensure that those services are signing up to GDPR compliance. And you need to bear in mind that, of course, a lot of these aren't EU based, they're US based, and therefore you've got that data transfer issue that we talked about before, which is why I laboured the point about international transfer and why that's important. So if you're the controller, you need to carry out due diligence on your processor and make sure the contractual terms are in place. If you're the processor, so you're a third-party marketing company, or you're providing software as a service in the cloud, or you're doing some data processing on behalf of your clients, then you would be a data processor. You can therefore expect your clients to carry out due diligence on you and wanting to know what's your position on GDPR, where's your GDPR statement. You're going to have to work out how you're going to get these contractual terms in place between you and them, and they may be enforcing them on you. But also, you've now got liabilities and responsibilities. So under Data Protection Act, the buck pretty much stopped with the controller. So even if the processor had done something that led to a breach or some particular issue, it would be the controller for not carrying out proper due diligence on their processes that would get the fine or the investigation. Under GDPR, the processor could either be as well as or instead of liable, so they could end up with the fine or the investigation or the telling off or whatever. So that means if you're a processor, you will now have liabilities and responsibilities that you didn't have before, and quite possibly if the data controller or your clients have carried out a proper GDPR exercise and are absolutely on it from their accountability point of view, so they're able to demonstrate that actually they've done all the checks and balances. You said that there wasn't going to be a problem, but there was. Then the finger of blame could easily switch over to you as the processor, which is why you as a data processor have to pay attention to GDPR, but you also need to understand the ramifications of what that actually means. More liabilities for data processors, I'm afraid. There's also an introduction of a concept tool called data protection by design and default, and a use of a tool called data protection impact assessments. The UK's had privacy by design and privacy impact assessments for some time as best practice, but not as law. The GDPR brings them in as law. So the premise is basically when you're processing data and you're doing it in a new way, or you're just determining a new set of data you're going to be processing, you have to ensure that data protection is considered by default. So not as an afterthought, but actually as part of the design and the development and of the project. And you can use a tool like the data protection impact assessment, which is a risk management tool that essentially enables you to determine that your processing is with data protection in mind. However, the DPIA's data protection impact assessments also apply if you're doing what's called high risk processing. And there's some guidance from Europe which sets out some of the ways in which that high risk processing or that processing might be considered high risk. That it's not in a brilliant set of guidance, because it kind of lists about 6 or 8 different scenarios and then says, you know, if you can tick 2 of these, then you probably are doing high risk processing and therefore you need to carry out data protection impact assessment. And then says, but under some circumstances it might not be 2, it might only be 1. So I suggest looking at that guidance and working out whether you need to carry out a data protection impact assessment. So if you're doing high risk processing now, according to the regulation and the guidance, you need to carry out a DPIA before the 25th of May when the GDPR comes into play. And any future processing as part of data protection by design and default, you will need to consider, are we doing high risk? If so, you'll need to carry out a data protection impact assessment. The regulation also introduces a data protection officer. Now, remember I said I became a data protection manager in 1998 when the Data Protection Act came into UK law. Well, that was just a job title rather than an official position that had any particular bearing in law. Under GDPR, however, it says under certain circumstances, certain organisations will need to have, mandated by law, a data protection officer. And the law sets out the expectations of the roles of what that data protection officer should be. Essentially, the law is to stop the business telling the data protection guy to go sit quietly and stop talking about data protection because it's annoying, and actually allow them to get on and do their job. But there's certain things and expectations that data protection officer will be expected to do within the organisation. If you need a DPO, you'll need to pay that, obviously pay attention to what those rules actually mean. In terms of who needs a data protection officer, if you're a public body, you need to have a data protection officer. You've got no choice about that. If you're a business, if your core activity is a systematic and regular monitoring of data subjects on a large scale, you'll also need a data protection officer. The problem is core activity, regular and systematic monitoring and large scale aren't clearly defined, but there is some guidance which goes some of the way to try and help give you some examples and interpret what those phrases mean. But you know, essentially, if your business is all about processing data, that's a core activity. If you're determining outcomes based on the activities of data subjects from the use of their data, then that's probably regular and systematic monitoring. And if you're doing it on a large scale, you probably tick all three of those, and therefore you'd need a data protection officer. The kind of example I usually get is somebody says, well, I'm an e-commerce site, I sell stuff, but I'm not large like Amazon, so therefore does it not apply? But we do some really clever stuff in terms of monitoring behaviors of our website users in terms of what they're doing, so we can determine advertising and so on. Well, that sounds like your core activity and your regular systematic monitoring is taken place, is taken care of. What about the large scale? You're not as large as Amazon, but you know, what are you selling? What kind of levels of the market do you have? If you're a niche product, you're selling niche products and you've got, say, 80% of the market, then there's a good chance you'll fall under large scale, even though you're not a massive organization like Amazon. So as I say, have a look at the guidance, because you'll need to understand whether you need a data protection officer. But if you're a public body or you meet those criteria, you need to have a data protection officer, and you'll need to pay attention to the specifics of the regulation in that regard. Right, nearly to the end. It's taking me a bit longer than I anticipated, but I'll still leave time for questions at the end. So we're on to breaches. Data protection, the GDPR has rules around data protection breaches. So if a breach occurs, you might need to notify the regulatory body if there's harm to the data subjects. If there's high risk to the data subjects, you'll need to tell the data subjects as well. You need to maintain a register of breaches so that you're able to demonstrate your decisions that whether to report a breach or not. And that doesn't mean, well, if we didn't report it, we just won't bother writing it down. If you get caught out, you'll need to be able to demonstrate that you'd thought it through and the processes you went through in terms of dealing with that. But essentially, it means that if something terrible happens with some data that you're processing, not only may you have to tell the regulator, who may take an interest into why that happened in the first place, but you'll need to tell your customers that maybe they might not want to trust their data with you for much longer because you've had these problems. So you know, it's quite an issue for businesses that if they have a breach, that they've got these duties. And it's also worth bearing in mind that breaches are more widely defined than just your typical cybersecurity hack. It's not all about teenagers hacking your customer database just to prove a point. It's any unlawful access to data, that which includes viewing. It's the accidental or not deletion of data or modification of data that's unauthorized. So breaches is much more than just your cybersecurity hacks. And then finally, just a quick word about fines. Yes, the GDPR does have 4% of global turnover, or 20 million euro, as its highest level of fine, and that's significantly higher than the $500,000 that we have at the moment under Data Protection Act. But the Information Commissioner has made it clear that not only are there other remedies, so you know, directors can be held liable, employees can be held liable if they've acted on their own accord and outside company protocol. But actually, you know, the investigations are proportional and taken on a case-by-case basis, and you can see that with the kind of things that they're doing, the Information Commissioner are doing from a data protection point of view under Data Protection Act. So don't think that this is all about 4% of global turnover or 20 million euro fines, because it's much more complex than that, and I'll be very surprised if we ever see anything that high. To give you an idea, Carphone Warehouse had a breach in 2015 due to poor security. Millions of customer and employee records were breached. They got fined 400,000 out of a maximum of 500,000. So yes, it'd be interesting to see what they would have been fined under GDPR. But again, it's an indication that they could have been fined a maximum of 500,000, but they weren't. So in terms of compliance and what you're going to do about all of this, well, there's kind of 6 things you might want to think about. So if you need a mandated data protection officer, he's going to take care, or she's going to take care of the first point. But it's probably good practice that if you're able to appoint somebody within your organization to take the lead role or be a champion for data protection to ensure that you're up to date and so on, because that will give you a focal point within your business. Carry out an audit of your data systems and policies, and I'll talk briefly about that in a second. Document everything, because that's the accountability principle. Demonstrate that you've thought things through, and this is the reason why you're doing this processing in this particular way, and so on. Have internal policies, and if you can, provide documents so that you can help your employees understand where to find information if they need it. Importantly, train your staff. If there's two things the Information Commissioner is going to do, they're going to want to know where's your training and where's your policies. So it's important to have those in place. And that, again, if you have somebody taking that single responsibility, you can instill a culture in the organization that understands how important data protection and privacy is to your organization, but also their role in that. And then finally, maintain your compliance and keep up to date. And I'll talk briefly about that in a second. In terms of preparing your business and carrying out an audit, you need to understand what you've got, data systems and policies now, analyze it to determine where you need to be. So sort of a gap analysis to determine where you are today and where you need to be GDPR compliant. That will help inform an action plan. So in the delivery phase, you've got an action plan setting out what you need to achieve and by what time. Include your employee training in that as well. And then again, managing ongoing compliance and keeping up to date. Now, what does that mean? I've mentioned that a few times. Well, data protection and GDPR is not just about the 25th of May. It will continue past the 25th of May. So you'll need to make sure that your processing is still secure, that your staff still understand what their duties and responsibilities are under data protection, that your policies are still relevant, that you keep everything under review. And don't forget, all these data subjects, even employees in businesses you're interacting with, all have individual rights. So you might have to deal with subject access requests. You might have to deal with making sure your privacy policy is up to date to meet the rights to be informed and so on. So the important message is GDPR is not just about the 25th of May. It's going to be here for and probably another 20 years, or until the UK introduces its own set of laws in the future in a post-Brexit world. But it is an ongoing thing. It's not just a one-hit wonder for the 25th of May. And the kind of things you need to keep an eye on is, as I mentioned, the Data Protection Bill earlier. That's coming. We need to understand what that might mean to UK law particularly. Also, SME privacy regulations, which set out what you can and can't do from a marketing perspective, and also the use of cookies and data used in cookie control and similar other things like Facebook pixels and so on. It's important you understand what's happening with that, because that could impact your digital marketing and whether or not you do need consent. That was supposed to happen 25th of May as well, but we're still waiting to find out what's happening with that. So it's unlikely it's going to happen in 25th of May, but might happen later on this year or next year, and could change the regime for digital marketing in the UK. There's also a lot of guidance to look out for. The Information Commissioner, who's our national regulator in the UK, and also all the regulators across Europe, they get together as the Article 29 Working Party. They're producing guidance as well. So you've got to pay attention to what that might mean in terms of interpretation of the regulation. Who knows what's going to happen with data flows and Brexit? If we're, at worst case scenarios, we're seen not to have adequate data protection, and that might mean if you're processing European citizens' data, you're going to have to consider what the ramifications of that might mean. So you need to pay attention to that. And finally, the enforcement. If a European regulator, say a German regulator, interprets the GDPR in a particular way, that could have ramifications on what is happening in the UK. The Information Commissioner's website is getting better and better by the day in terms of resources available, but and here's a quick sales pitch. Whilst that all seems like doom and gloom because there's so much to think about, that's what I'm here to help with. I run Digital Compliance Hub, which is an online service that provides a mix of guidance and tools, but also a helpline that can help you with your data protection, your GDPR, your privacy and marketing compliance, and your web and data security as well. And if that's not your bag, then I'm also a consultant. So I provide consultancy services ranging from GDPR compliance audits to data protection officer roles, by the hour consultancy, training and advice and so on. So if there's any doubt, this is what I do for a business. I'm not a random marketing guy talking about it because you need to think about it, or an IT specialist telling you that you need to think about it. I'm all about helping businesses with GDPR, their privacy and marketing compliance, and how to secure their data. So we've got about 6 minutes until the webinar is due to end, but I've got plenty of time if you want to ask any questions. There's the questions section in your GoToWebinar control panel, which you can use to ask those questions. There's none coming through as I was talking, but feel free to start pushing those through now. If you've got any questions, I can try and answer those for you. So right, thank you, David. I've got one coming through now. How does GDPR affect small businesses like a single sole trader in terms of record keeping and reporting? Well, I'm afraid if you process personal data, which if you're a business, you'll be likely to. I've yet to find a business who's not processing personal data. Then I'm afraid GDPR applies. So it doesn't matter whether you're a small business or a big business, whether you've got one data record or a billion, GDPR applies. However, from a pragmatic point of view, it's about, well, what can you do in your business to ensure as much as possible that compliance? And whilst there's an element of, well, how would somebody know if I wasn't compliant? Well, that depends on whether you've got clients who wish to complain about you, in which case that's when you get found out, and then you've then got to be able to demonstrate that you've thought this through. So I'm afraid it doesn't matter whether you're a small business or a big business, a sole trader or a limited company, data protection applies, and you'll need to pay attention to this. In what detail will really depend on you and your organisation and your process, I'm afraid. And what I will say is the Information Commissioner has got a small business helpline and lots of information to help with small businesses, because they recognise that small businesses probably don't have the resources to do a lot of what's required. However, whilst that may sound helpful, there is the issue with the fact that they are the regulator, so they might be slightly vague in what they're telling you from an advice point of view, because as soon as they tell you something very certain, then that becomes regulation and or interpretation of the regulation. So they've got to be very careful about that. But that's why I run services like the Digital Compliance Hub to help businesses as well. So I hope that answered your question. Any others? Nothing else come through so far? If there are no other questions, then I'm happy to leave it at that. We're pretty much on time, but I'm quite happy to sort of stick around for another couple of minutes if that's helpful. Okay, well, nothing's come through. Let me just give it a couple more seconds just to be sure that nobody's busy typing away. A few thank yous. Thank you for your thank yous. Right, okay, well, no questions coming through, so thank you very much for joining. I hope that was helpful. I'll be in touch with a link to a copy of the slide pack in case that's of help to you, and also a recording so you can go back over the different points that I covered. Oh, hang on, questions just come through. Thank you, Daniela. What is high-risk processing? What it involves? Well, the kind of things that would be considered high risk would be high risk to the data subject. So there is a class of data that's referred to as special categories of data. They are things like health records, sexual preference, religious beliefs, trade union membership, biometric data. If you're processing those kind of data, then that may be construed as high risk, and there's certain rules around what you can and can't do with that data, and that you certainly need a much higher level of consent with regards to that kind of processing, depending on what you do in your organization. There may be other conditions like you're processing large quantities of data, you're doing automated decision making. So one of the rights is that an individual has the right to withdraw or basically say they don't want any automated decisions to be made with that using their data. So if you're doing things like credit checks and using automated tools to actually determine a credit rating or anything like that, then that may also be considered as high risk. If you go to the Information Commissioner's website and look at data protection impact assessments, under the GDPR section, it will give you a link to the European guidance. And as I say, that in there, I think I said earlier, there's a list of about 6 or 8 things that might be construed as high risk. And to be honest, it's a case of interpreting what that might mean, because it isn't highly helpful, but it does go some of the way. So I'd say have a look at that, and it will give you a clue about what some of the things might be considered as high risk. Okay, let's leave it at that. Thank you very much for your time. Thank you for joining. I hope that was helpful. And as I said, I'll be in touch with a copy of the slides and a recording of the webinar, so you can go back on that if that's of use to you. Thank you very much, and enjoy the rest of your day.